So the Arms Trade Treaty is an international, in my view, disarmament treaty that establishes criteria for when the transfer of conventional arms may be lawful. So by conventional arms, of course, we mean arms other than weapons of mass destruction. Now, the Arms Trade Treaty does not cover every single conventional weapon, but it does cover the vast majority. Perhaps notable omissions are hand grenades, for example, hand-in-place anti-personnel mines, for example. But it's a disarmament treaty with a very strong humanitarian element to it. So when a state is considering transferring, exporting to another country, it has to look at what will be the consequences if we transfer those weapons. How are they going to be used? Are they going to be used in accordance with international law? If not, what is the risk that they are going to be used in violation, and how, if possible, can we mitigate those risks in order to allow the transfer to go ahead? Well, right at the outset, there was this almost banal statement that bananas are more regulated than arms. And at the time, it was true. There was more international regulation of fruit than there was of these deadly weapons. That clearly cannot be right. There were more informal political arrangements, one called the Wassenaar Arrangement. The EU has a position on arms transfers. Obviously, domestically, some states have prohibitions or moratoria on certain weapons, but to not have this sector regulated was a clear anomaly, and to a certain extent, I think we've addressed it. Well, probably the biggest innovation was this idea that international human rights law, international terrorism law, international humanitarian law are criteria that an exporting state must assess when it is considering authorizing a transfer. And it must consider whether the arms, for example, might be diverted to illicit purposes, or whether, and if so, what the likelihood was that those weapons would be misused. It was possible to argue by analogy beforehand under the law of state responsibility that there were already obligations, but there wasn't the clear and fast rules that we have set out in Article 7. And for that reason, in the commentary, a lot of space is devoted to that provision, because I think it is an innovation in international law. The old joke about what's the difference between a pessimist and an optimist. A pessimist says things can't get any worse, and an optimist says, oh yes, they can. And that's the danger that we find ourselves at the moment. And there's one particular scenario that brings that to the fore, and that's Saudi Arabia and the coalition's use of force in Yemen. I have argued quite strongly that the UK and other European and Western nations that are supplying weapons to Saudi Arabia, given how these weapons are being used in Yemen, is a violation of international law and a violation of the Arms Trade Treaty in particular. It is clear that some of the targeting in Yemen has been indiscriminate. Indeed, earlier this summer, we saw the British government tell Parliament that, in fact, when they said they had assessed the risk of Saudi Arabia misusing these weapons, in fact, they hadn't assessed the risk of Saudi Arabia misusing. That is a very clear admission of an arms trade treaty violation. Now, subsequently, in the autumn, they have backed away from that position, but they've gone on to even more dangerous territory by suggesting that you only prohibit a transfer if it's going to be used for a war crime. That's not what the treaty says, and we make that very clear in the commentary on Article 7. A serious violation of international humanitarian law, yes, includes war crimes, absolutely, but it is not limited to war crimes. It includes indiscriminate attacks, even where you don't have the requisite mens rea, the requisite intention to kill or injure civilians. Although I made clear my concerns in particular around transfers to Saudi Arabia based on what is happening at the moment, that does not mean that the treaty is a failure, because it's not. It doesn't mean that the treaty will be a failure, because I don't believe it will. It was clear at the beginning of the negotiations, you don't turn around a $60 billion market overnight. It takes time, it takes effort. And I think we will need to look back in a decade from now to really assess how the ATT has hopefully worked, and where there are problems, what those problems are and how we can address them. It would be too soon to make a judgment either way as to the success of the ATT, but I think the fact that it exists, despite opposition from a small number of states, the fact that it exists is a first step. The ratification levels are increasing, that's positive, but we do have concerns about implementation. There is a clear requirement to set up a control regime, one that makes these assessments, assesses whether weapons are going to be used for crimes against humanity or war crimes, assesses, if not, whether arms are going to be used, or what the likelihood is that arms are going to be used in violation of human rights law or international humanitarian law. In terms of the establishment of the control regimes, I think we can see some progress. States are setting up the requisite interministerial or official bodies to do those analyses. I think, though, internationally, the implementation has been more problematic. And we see that in the context of the annual conferences of states parties. States parties to the convention get together once a year formally to look at the status and operation of the convention, and it is clear that they are very reluctant to look at the criteria for transfer and how those are being applied. They're much happier talking about universalization of the treaty and the establishment of the control regime. Those are important, but so are the criteria for arms transfers.